Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today about one of my favorite topics in law, which is choice of law and conflicts of law. This is heady stuff, but it is extremely important, particularly in the realm of non-compete litigation. So let's go ahead and get into the mix. Non-competes are contracts. These contractual agreements show up principally in two different arenas: the employment context and the sale of a business context. Most contracts today that are drawn up by any business of any significance will contain the following provisions, among others. Will contain a forum selection clause and a choice of law provision. Let's unpack this because some people tend to conflate these things. A forum selection clause indicates where litigation, arbitration, etc. must be brought. Let's focus on litigation. Let's take arbitration off the table. A forum selection clause will say any litigation pertaining to the subject of this contract must be pursued in the Middle District of Florida, or in the state courts of Pinellas County, Florida, or what have you. That is the forum where litigation must be pursued. And anybody who follows me is well aware that, I hope and pray it's not limited to state court, and the forum's not, the circuit court of Pinellas County, Florida, or what have you. It's not a knock against that particular court. It's just that it's much easier to defend these sorts of cases in federal court, particularly if you have complicated choice of law and conflicts of law sorts of issues. So that's a forum selection clause. It's going to say the forum where litigation must be brought. On the flip side, you have choice of law provision. And choice of law is exactly that. It provides which law will govern. So you have contract says forum is in Middle District of Florida, state or federal courts. Choice of law shall be Florida law. Now, a lot of these contracts use this language where they say Florida choice of law shall apply regardless of any conflicts of law principles. Well, that's nonsense. That's nonsense, because a choice of law provision like that, depending on the exact context, can implicate the interests of not just the parties to the contract, but also the states that have, interests in the outcome of the litigation. So you can't waive those conflicts of law principles. You can put it into your contract, but you're not going to be able to waive that. A court is still going to do a traditional choice of law and conflicts of law analysis. So you have a forum selection clause, you have a choice of law provision. Your choice of law provision says Florida choice of law. Is it necessarily enforceable because the parties agreed to it? No, it's not. Forum selection clauses are almost always enforceable. Courts will almost always honor the selection of the forum because there's not really a whole lot of other interests attached to forcing someone to litigate in a particular location. That's it. A forum selection clause just says you have to litigate in Florida. You have to litigate in New York. You have to litigate in Virginia. You have to litigate in Arlington. There's nothing else attached to it. It's just saying here's the forum, here's where litigation has to be brought. But when you get into choice of law, that's where you pull in all sorts of other interests in terms of, you have a choice of law provision that says Florida choice of law. The person, the defendant who's being sued for violating a non-compete agreement lives in, for instance, California, where employee non-compete agreements are unenforceable. That creates a big sort of federalism, public policy. California's interest is at stake. You have a California citizen who's involved in defending this case. There's much more there when you look at choice of law than there is when you simply look at a forum selection clause. So don't conflate the two of these. Whereas a forum selection clause will almost always be enforced, a choice of law provision will not necessarily be enforced if it creates a conflict of law with another state that's got a stronger interest. So I'm just going to give you some examples of how this can shake down. You have sort of the hypothetical that I just laid out. You have an employee who works in California for a company that's based in Florida. This person has never worked in Florida. They've only ever worked in California. They still live in California. They quit their job at this company and they want to go work for a competing company. The company, which is based in Florida, sues them in Florida for violation of their non-compete agreement. This raises substantial issues about the interplay between Florida's interests in protecting the rights of the corporate citizen that's based in Florida and California's interests and the interest of this individual who lives in California, has worked in California, and has never come to Florida for any purpose, but is going to come here to litigate this non-compete agreement. That's the sort of context where you'll see the court run a choice of law and conflicts of law analysis. And this gets extremely technical, and it gets back into what is called the restatements, the restatement choice of law, the restatement conflicts of law. This is the sort of thing that can only be handled by someone who has significant experience litigating choice of law and conflicts of law issues. I'll give you another example from a very recent case, and this is absolutely somewhat shocking. This is the Prosperity Bank case, and this is out of Texas. There was a bank based in Texas. There were some individuals who worked in Oklahoma for a different bank. That Oklahoma bank was acquired by this Texas bank. These folks continued working in Oklahoma for the Texas bank, the acquiring bank, and they all signed non-compete agreements. They then left that bank to go work for a competing bank. And the corporate parent bank in Texas sued them in Texas for violating their non-compete agreements. And there was a huge choice of law fight where the plaintiff insisted that Texas law should apply. The defendants, of course, insisted that Oklahoma law should apply. Why? Because Oklahoma law is far less favorable to non-compete agreements. Ultimately, the court found that Oklahoma had a materially greater interest in the dispute, applied Oklahoma law, and found that the non-compete agreements at issue were unenforceable. That is the classic sort of choice of law, conflicts of law scenario. What's the upshot of all this? Well, I'll tick off the following points. Number one, you should always look at choice of law and conflicts of law. You should always consider it. You should always run the analysis, because you can't look at a contract and just off the top of your head guarantee that the choice of law provision is going to be upheld. The contract may say Florida law, but you need to really dig into it. You need to get all of the facts. You need to muster all of the facts. Where was the person working? What office were they based out of? How much contact did they have with Florida? Where did they sign the contract? X, Y, Z. You want to get all of this stuff. And then you want to run the choice of law analysis. Why? Because the state-to-state variation between non-compete law from one state to the next is absolutely tremendous, and in some instances can be dispositive. Florida, where I practice, is perhaps the most aggressively pro-non-compete state in the entire country. I can tell you off the top of my head that there are a number of cases where a non-compete would be enforceable under Florida law, but it would be unenforceable under North Carolina law, under Illinois law, certainly under California law or Oklahoma law. That's why it's so important to run the choice of law analysis, because the variation is tremendous, and in some cases, it can absolutely come down to winning or losing the case. So, number one, choice of law matters. It's important you run the analysis. Number two, because the variation from state to state is so tremendous. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question about choice of law and conflicts of law, or if you have a non-compete question generally, please feel free to call my office. Be happy to talk with you. Thanks for watching, and have a good day.